Welcome, everyone, and thank you for joining us tonight. We're deeply grateful to all of you for spending the time to join us this evening and helping us honor Judge David Tatel as the 2024 Gould Book Award recipient. Tonight gives us the opportunity to celebrate this prestigious award to a very worthy honoree at our new Cross River campus. Since opening the campus, 3 Times Square has served not only to house a number of our schools, but also our executive offices, and most recently, a branch of the Touro Law Center located on the 11th floor of this building. The main reason we're here tonight is the gentleman who's sitting in the first row over here, Bruce Gould, a friend, and an alum of the Touro Law Center. When Dr. Andrew opened the Touro Law Center, he hoped to attract excellent individuals who would not only study the law, graduate and become attorneys, but also those who would make outstanding contributions to society. Bruce entered the Law Center in 1980. While there, he served as the 2nd president of the Student Bar Association and graduated with our first 4-year class in 1984, receiving his JD. In 93, he also received an MLL from NYU. He played a vital role in his family business, Gould Public, that began in 1953 and specialized in law books and treatises for the public legal community and the law enforcement community. When it was sold in 2004, it was one of our country's leading statutory law book publishers. In 1990, Bruce established the Bruce K. Gould Book Award. Today, this tribute is the country's most prestigious award for the best book about legal topics and affairs. In 1994, Bruce also endowed the Law Center's first faculty chair, the Bruce K. Gould Distinguished Professor of Law, currently held by Professor Elena, who I believe is here with us tonight. He's also served on numerous charitable and philanthropic organizations and boards. His family's love and support of education are exemplified through the creation of naming gifts at multiple institutions. At Touro, Bruce's dedication has been unwavering. In recent years, he's expanded his leadership from the Touro Law Center Board of Governors to chair the Touro University Board of Governors, and we appreciate all that Bruce has done for us. I could speak for a long time about Bruce, but we're actually here tonight to hear about Judge Tatel's book. So I'm going to stop there. And I want to congratulate you. I'm very much looking forward to hearing the discussion, and congratulations on the award. Bruce, can you come up and join us here for a couple of pictures, and then we'll begin the actual real part of the program.
Yeah, he's going to speak, and then we'll do the pictures.
Oh, Bruce can speak first. Yes. Welcome.
Thank you so much. Thank you, Dr. Kadis, for that wonderful introduction. What people don't know is Dr. Kadis flew in just from LA just for this award presentation. So thank you so much for taking a special trip. I know that it's a long trip, and we really appreciate you being here. I want to tell you, your leadership in making Touro University such a great, innovative institution is truly amazing. Just recently, about 11 months ago, I had a chance to, about this time last year, go to a university board retreat with leadership, and I was in awe at the advancement, size, and scope of the programs this university is offering. Dr. Kadis, thank you for being a great mentor, great friend. Thank you. Rabbi Krupka, Dean Langan, the Bruce K. Gould Distinguished Professor of Law, Rena C. Stepowitz. Where is she? There she is. Thank you. And the Gould Distinguished Professor of Law Emeritus, Richie Klein. Are you here? No, he will be here. I know he said he never misses them. Members of the university's board, members of the Touro community, faculty, students, friends, and especially our amazing award recipient, Judge David Tatel, who is being honored tonight for his book, Vision, a memoir of blindness and justice. And I can't forget to also recognize Vixen, who is sitting there and part of the program. So he's a very important part of the program tonight. So I want to recognize him as well. It's a great pleasure to welcome you to 2024 president of the Touro Law Center Gould Book Award. As Dr. Kadis said, it was 35 years ago when Howard Glickstein, who also I know is going to be here tonight. Did he get here? I don't see him yet, but he will be here. We sat down and we came up with a notion of creating a program that would bring notoriety to a relatively new law school and expose students to distinguished speakers and guests. We discussed a number of ideas and eventually centered on this award to honor the author of an outstanding publication related to the law, the legal profession, and our legal system. I don't think either of us could have imagined, and some of the people tonight were telling me all the different ones that they had come to over the years and the honorees we've had. And Judge Tatel mentioned that he was amazed along with his wife. I want to recognize, where is she? Right here. Thank you so much for being here tonight. It's been truly amazing, and it's been a pleasure. The quality, variety, and prestige of the recipients have been tremendous over the years. I just want to mention a few that I especially had a love for: Justice Sandra Day O'Connor, Justice Sonia Sotomayor, Alan Dershowitz, Bob Woodward, John Grisham, U.S. Senator Daniel Patrick Moynihan, Christopher Dodd, Amy Klobuchar, former vice presidential candidate and U.S. Senator Joseph Lieberman, just to name a few. And Senator Lieberman, we have a new documentary that just came out on his life, and it's amazing. And I encourage you to go see it if you get a chance. It's going to be playing at theaters around New York. So tonight we had Judge David Tatel, who so eloquently tells his story of serving on the second highest court in the land, the U.S. Court of Appeals for the D.C. Circuit, with the challenge of being blind and fighting for justice over the many things. Even without eyesight, got to be an inspiration to all of us. How great that is. Judge, thank you for being here tonight and honoring us by accepting this award. We so appreciate it. Dean Langan, congratulations for putting on another fantastic. One just is better than the next, and I really appreciate it. Associate Dean Hagan, this is our second year doing this, and it's been a pleasure working with you. And I'm looking to many more years of collaboration and many more great events. To your staff, kudos on a fantastic job. They put it all together and do everything. Makes my job easy. There are a few people I'd like to recognize here tonight. My brother, Jeffrey, who's been my friend and my best friend. And he's always here for me, and I really do appreciate it. My cousins, the Grunwalds, I know they're here somewhere. Thank you so much. And all my friends for being here to support this wonderful Simca. On behalf of the law school, university, and my family, I want to welcome you all to this very special evening. Please enjoy the presentation.
Thank you, Bruce, and thank you, Dr. Kadis, for being here today. This is one of the law school's signature events. And before we start, I want to highlight some of the recent accomplishments at the Touro Law Center. We are truly a vibrant law school, and we now have the Manhattan campus in this very building on the 11th floor, as you have heard. We matriculated our first class this fall, and we're very pleased to be back where our roots originated. We started in Manhattan, and we're back here, and we have our campus still in Central Islip. We also started 2 new institutes this year. We have a Trial Advocacy Institute and also an Institute for Health Law, Policy, and Bioethics. Both are being kicked off this year, and we hope to involve students in each. As far as the Trial Advocacy Institute, it will provide an opportunity for students really to hone their skills as advocates, and it will also be a resource for the community, providing CLE programming for lawyers in order to better their skills, to try out some of the new courtroom technology, and of course, deal with AI in the courtroom. Our Institute for Health Law, Bioethics, and Policy is an interdisciplinary institute that also involves our health science groups here at Touro. Touro really is known for its health programs. It has multiple medical schools, both allopathic and also osteopathic, as well as health science programs. And our health law program will allow the law school to partner with these schools in order to create interdisciplinary opportunities for the study of law, as well as the study of health-related issues. The last thing I want to mention is our small business clinic. As a result of funding from a Representative Garbarino in the U.S. Congress, we received a grant from the Small Business Administration, $475,000 grant, to start a small business clinic on Long Island that will service both Nassau County and Suffolk County and deal primarily with minority and women-owned businesses. It's a new venture. We just started it this fall. We have a new faculty member who's in charge of it, and we're looking forward to doing some great work on Long Island. So you've already heard about Judge Tatel, and yes, it's pronounced Tatel. We've heard a lot of different pronunciations. The only reason I know it's Judge Tatel is because I listened to part of the book on Audible. I read part of it and then I listened to it. So I was able to learn the correct pronunciation of today's recipient. Judge Tatel truly is an inspiring jurist. He served on the United States Court of Appeals for the DC Circuit, which is the country's second highest court. He has been a champion for equal justice throughout his entire adult life, and we'll hear about some of that hopefully today. He has decided landmark environmental and voting rights cases, and he truly has embodied the ideal of what a great judge should be, even though he has been blind for the past 50 of his 80-plus years. His book, A Vision, A Memoir of Blindness and Justice, is an inspiring story, and I'm grateful that he, along with Vixen, his guide dog, as well as his wife Edie, are here with us today. I'm looking forward to having an engaging conversation with the judge, dealing with both his struggle to acknowledge his deteriorating vision, as well as his perspective about some of the landmark cases that he was involved in and the future direction of the current U.S. Supreme Court. I do want to extend a thank you to Professor Roger Citron, our Associate Dean for Research and Scholarship, who introduced us to Judge Tatel. He was going to have Judge Tatel come to his class and also have him have a colloquium for our law faculty. And as soon as we heard that he had connected with Judge Tatel, we decided to co-opt him and instead invite him to be our Gould Book Award recipient. So at this time, I would like to invite Dr. Kadish and Bruce Gould back to the stage. We will present Judge Tatel with his award, and then we will proceed with the program. And stay right there, Judge. All right. Yes, I have a very, very heavy award, which I will hold. It is a set of bookends, which has the Touro logo on one side and also an inscription designating you as the recipient this year. And I hope you got Vixen in those pictures. No. Judge, you can have a seat. Thank you very much. So throughout the program today, if you do have any questions, there should be pens or pencils and index cards at your seats. Please write down any questions, and at the end, we will have an opportunity for some Q&A, which Professor Sitpon will lead. But I get first dibs at the judge, so. So Judge Tatel, you were a lawyer. You were an advocate before you became a federal judge. How did your experiences as a lawyer inform or influence how you performed your role as a judge? And this is a compound question, which I know no litigator should do. But more specifically, you've been characterized as a judge who believed in and acted with judicial restraint. Did you follow that in any way, or did that follow in any way from your experiences as a lawyer?
I will answer your question, but may I say something first?
Absolutely.
I'd like to just express my thanks on behalf of not just me, but me, to this award. Dr. Kadish, the Langan, Bruce Gould, and the entire Gould family. We started this whole. Roger told me to argue the case.
Just when your mic is off, and you'll also notice that probably of South down. I think it's in the center box. Oh, sorry. Just grab it. And then you notice the mic slid down. Okay.
Here it is, right there.
The wonders of technology.
Is that fine? There we go.
Yes,
Yeah.
much better.
So I was expressing my deep thanks to President Kadish, and Dean Langan, and Bruce Gould, and the entire Gould family for this lovely award. I'm thrilled that you're recognizing vision. And it's especially thrilling to me because I spent some time looking the mission statement of the Touro Law School. And I noticed its emphasis on the pursuit of social justice. And that makes this award even more meaningful. In a way, vision and the Touro Law School are on the same wavelength, and that really does make this a very special evening. So thank you.
Absolutely.
So yes, I practiced law for 30 years. I was a litigator. I litigated in the federal courts, and in 1994, I became a federal judge, which was pretty dramatic. Many federal judges go from being district court or trial judges to appeals court. I went straight from the practice of law to being an appeals court judge. Now, I had a very good sense of what federal judges were and what their responsibility was, all the way back to when I was a college student in the 60s and became a huge admirer of the Southern federal judges who took their oath of office seriously and rose above their segregated roots and enforced the 14th and 15th Amendments. Those judges were enforcing the most important provisions of the Constitution of the United States. And then for 30 years, I litigated in the federal courts. I tried civil rights cases for some of the finest judges in the country. So by the time I got to the DC Circuit, I had a really good idea what a federal judge was in our constitutional system. The challenge was, how do I become one? And the hardest part of that, was switching from being an advocate representing a client being a federal judge responsible for enforcing the law objectively, regardless of what my own policy views were. What helped me make that transition was all the way back to my years at the University of Chicago Law School and my own reading of the law and Supreme Court cases. I came to understand the importance of principles of which are critical to preserving the checks and balances in our government. And they were also the way in which I was able to function as a judge to set aside my own policy views. The principles of judicial restraint can be frustrating, but I found them deeply reassuring, because by applying them is by careful respect for the language of the Constitution, statutory text, and our own precedent, and the limited jurisdiction of federal courts, by trying as hard as I could follow those. I believed that I was applying the law and setting my own views aside, and that's where that comes from, Dean.
Great. One of the wonderful aspects of the book is your candor in describing your affection for Vixen, your guide dog. You also talk about having her changed your marriage. Can you say a little more about that? And if I can bring your wife into the discussion a bit more, did writing the memoir prompt you to think differently about your relationship with her?
This book is candid, but I'm not sure it's... Would you just raise your hand here so people know where you are? Okay. This is labeled as my memoir, but this is very much our memoir. We wrote it together, and it's our story. When I met Edie, almost 60 years ago in Chicago, I was sighted. She met a sighted person. And it wasn't until about a month later that I sat down on the shores of Lake Michigan and I told her about my eye disease, retinitis pigmentosa. She was actually the very first person who I really confided to deeply about my eyesight. We were young, we were optimistic, we were falling in love. It didn't seem like, and I had never been told what the future was. In fact, I have been told no one knows what the future is with retinitis pigmentosa. So we got married several months later, and that's the beginning of our story. Now, blindness this was not just me dealing with blindness, it was both of us. It was different for each of us, obviously. It was hard for me in many ways. It was hard for Edie in other ways. But the book is a story of how we adjusted to that and dealt with it in our long marriage, including having children, process when I was in my mid-30s of going from sighted to unsighted. We went through that whole process together. And I was told by my editor when I wrote this book, when you're writing a memoir, you're supposed to tell the facts. Show, don't tell. That's the word. So I've told my story in this book, and I trust my readers to draw their own conclusions, but I'll tell you right now that when you read this book, you will read about my wife, one of the most magnificent human beings there is. And I guarantee you, and now I'm violating my editor's rule, reach the conclusion that I would not be where I am but for my wife.
a wonderful, wonderful response. Now, there were periods where you tried to hide the fact that you were losing your vision. Can you talk a little bit about the lengths you went to in order to make sure that individuals weren't aware that you were having vision problems?
Yes. So there are basically two stages. I was 15 years old when I was told that I had RP. At that point, the only problem was I couldn't see in the dark very well, and my peripheral vision was limited. But I was able to function pretty much as a sighted person for the next 15, 20 years. During that period of time, I hid it as much as I could. I hid it completely. What 15-year-old wants to be different from his friends? I didn't come back from NIH and say, oh, guess what, guys? I have a genetic eye disease. Instead, I hid it. I think there was a certain amount of shame, worry that people would think of me. And then as I graduated from law school and started practicing law, I worried that what would happen to my future employment opportunities if people knew I had a visual disability. Well, then flash forward to the mid 70s. I'm the director of the National Lawyers Committee for Civil Rights Under Law, and my sight takes a dramatic downward deterioration in just 6 months. And at that point, it was impossible to hide it because I started using readers. I tried to learn Braille. And eventually I took the difficult step of getting a mobility kit, but still, I never talked about it. I say in the book, and I went on the DC circuit, wanted to be known as a judge who happened to be blind, not a blind judge. And to me, that was a really big difference. And I spent 30 years driven to demonstrate to the world that I could succeed at the highest levels in the federal courts, even though I couldn't see a word of any of the briefs. I haven't asked this question, but the natural question is, so what changed? Well, two things changed. First of all, writing the book. Writing a memoir is an extraordinary experience. And in the process, Edie and I talked a lot about how I and we dealt with my sight. And the more we talked about it and the more I actually wrote, the more I became comfortable talking about it and writing about it. And so by the time we were done, I was in a place that I hadn't been before. There's no way in Langan that 5 or 6 years ago, I would have ever had a conversation like you and I are having in public. Wouldn't have done. But the book made me far more comfortable. The second thing is this marvelous creature here at my feet, Vixen, a now 7-year-old German Shepherd who I've had for 5 years. So when you're walking around with a mobility cane, people don't come up to you and say, hey, that's a really cool cane. Yeah, work. How do you get across the street? People don't talk about it. That is, having a guide dog, it's a different world because everybody wants to talk about the dog. Strangers will stop me on the street when I'm waiting to cross. So they'll say, does that dog get you across the street? Who trained her? What's her name? Lots of questions. You can't have a guide dog and not be uncomfortable talking about blindness. And so the combination of the book and the dog and many other factors that I write about in the book have brought me to a completely different stage and led me to be quite comfortable talking about these issues.
So your cane and Vixen help you in terms of moving around and finding your way in society. What did you do in order to compensate for your deteriorating vision as a judge? How were you able to function? What kind of assistance did you need and what did you rely on?
There's a simple answer to that. question, and it's called technology. Let me just give you one example, because I love technology and gadgets, and we could talk all evening about this. That's not what we're going to do. When I went on the court in 1994, in addition to my 4 full-time law clerks, I had a full-time reader, a college graduate who worked for me for 1 year, and a part-time reader. And these 2 young people read everything that came across. They read all day long. These people were in my office. They read briefs. They read memos. They read letters. When Edie hadn't yet read me the papers in the morning, they read newspapers, everything. 30 years later, my last year on the court, I had just 1 reader. I didn't any longer have a backup. I'd say they read 1% of stuff to me. Because in that 30 years, the world went digital, as did my court. And with technology, text-to-speech technology, which has gotten dramatically improved, I can now read virtually everything myself. And I could go on and on about technology and what a difference it's made, but what technology has done for me and other blind people is allowed us to function independently. That's the gold standard. There are so many things that I can't do. I yearn to do things myself that I can. One of them now, and it didn't used to be that way, is reading. Reading's an important part of my life, and now I can read myself. Sure, Edie and I like to read books together. We listen to books together. Every once in a while, she'll read me a short story that she likes. But generally, I can read everything myself. So the reading, the technology, has given me enormous independence, as has fiction given me physical independence. So, I mean, that's a simple answer to a very complicated question.
And you write about a case or two in which you considered recusing yourself from the cases because of your visual impairment. Can you talk a little bit more about that?
Yes, this is something that this is an issue that's in the book now because my editor and others who I care about asked me the question about whether I had ever recused myself because of my blindness. And I tell a story in the book. It was a case involving a suit against the Treasury Department, which by law is required to make paper currency accessible to the blind, which had never done it. This was a lawsuit to impose time frame on Treasury to comply with the law. And I was randomly assigned to the panel. My court sits in 3-judge panels, and we're assigned to them randomly. The cases are assigned to the panels by the clerk's office. So I was randomly assigned to this case. And now I had really strong feelings about this case. When I travel to other countries, we go to Mexico regularly. I can tell the difference between a 10 peso and a 20 peso note because they're different sizes. But I can't tell the difference between a 5 and a 10 here. And at least for me, there's nothing more embarrassing in a taxi. Say to the cab driver, is this a 5 or a 10? I didn't like that. And I objected to my government putting me in that position. So I had strong feelings about this case. And what I had to decide was whether I could sit on it. The law requires that judges recuse themselves, that take themselves off a case when it's almost a quote from the statute, impartiality might be reasonably questioned. I think that's one of the most important few words in the law because it is designed to ensure that the courts are impartial. Unlike members of Congress who run and get elected, federal judges serve for life. And our credibility, the respect for the court comes from the fact hopefully, that the public believes we're impartial and aren't pursuing either a political or personal. So I had to ask this question: should I sit on the case? I asked my colleagues on the panel what they thought, and they said, of course, you should sit. And while I appreciated the confidence, I recused myself from the case. And I did it not because I didn't think I could decide the case. I didn't have any doubt in my mind I could make that decision without regard to my strong feelings about the case. But I recused myself because I was worried what the public would think. I worried that even though it bothered me to think members of the public might think that I would pursue my own determination to have accessible currency instead of apply law, even though that really troubled me, I decided that it was in the best interests of my court, the integrity of the court's ultimate decision, and indeed of the legal system, that I not sit. Now, the rule I applied, it's in the book, is called the Tatel 5-minute rule.
Mhm.
What that means is, and I used this for 30 years, worked really well. If I had to think about an issue of recusal for more than 5 minutes, it didn't become clear after 5 minutes, that was it. I got off the case because it gave the benefit of the doubt to the integrity of the courts. That's what I thought was really important. So that's the decision I made. There were other cases where I decided not to recuse myself, and I talk about them in the book, but hopefully you'll read the book and read those chapters also.
Well, following up on that, then the blindfold on Lady Justice is now understood to indicate impartiality. How does that symbol resonate with you, and is it still apt?
Well, as I said, I think impartiality is absolutely essential to the integrity of the federal court system. Which brings me to the other thread of this book, justice. I want to emphasize that this book, justice part of the book, the last third, is about the court as an institution, not about any individual members of the court. I don't talk about motive. I don't talk about why a justice decided a particular case. Talk only about the institution and its opinions. Courts speak through their opinions. By looking at the opinion of the court, where you can tell whether or not what the court has done is a legitimate act of judging or whether something else is going on. If you read an opinion of the court and it's overruling a precedent and it isn't convincing as to why, you want to ask yourself what's going on with that court. Or if the court has written an opinion that seems to you to depart from the Constitution or statute, and it doesn't explain why, the public can reasonably ask, what's going on here? So that's what the last part of my book is about. And it's about the court's decisions in the environment and voting rights. And I examine their opinions, ask whether they are legitimate acts of judging, or whether readers looking at this might wonder about the impartiality of the justices who wrote the opinions. That's what the book is about. And my concern, and one of the 2 reasons I wrote the book, is that I worry that our current court, not just the Supreme Court, but increasingly the lower federal courts, have departed too often from the principles of judicial restraint that are critical, preserving the checks and balances of our government and the impartiality of the courts, leaving the impression that maybe something else is going on here than judging. That's the concern I express in this book.
Becoming a little more specific on that issue, what are your views on the relationship between politics and law, and specifically, for example, in an area like administrative law? And has your view of this relationship changed over your lifetime? It does appear from your book that it has, but what are your views on that?
So the dean has asked the question about something called Chevron. You probably all read about it. It used to be a binding Supreme Court decision. It's now been overruled. And if I could just read a minute or two from a
Absolutely.
passage in the book, which to me describes what's at stake in this issue. I mean, administrative law sounds, pardon the expression, isn't to me, but it sounds boring to lots of people. It's actually really, it has to do with the way our administrative agencies in this country work and how they do their job, and which is what's at stake under our current board. So let me just find this. Okay, this takes, bear with me for a minute or two, but okay. It all starts with the Clean Air Act, and I'm using the Clean Air Act of dozens of statutes. You could write the paragraph I'm about to read you about every one of these statutes. It all starts with the Clean Air Act, a landmark federal law that has saved millions of lives in the half century since it was enacted. In designing the statute, Congress recognized that air pollution is a dynamic problem. New harmful pollutants will continue to be identified. Science of pollution mitigation will continue to change. And industry will continue to find new ways around whatever rules Congress puts in place. So Congress crafted a dynamic solution, set up the basic legal framework, controlling air pollution, left the details to a specialized federal agency, the Environmental Protection Agency. There are good reasons why Congress did this. Like other federal agencies, EPA is part of the executive branch. Led by the president, the executive branch is more flexible and more fluid than Congress. Whereas members of Congress, like judges, are generalists. Each federal agency is staffed with subject matter experts who know virtually everything there is about the area they're regulating. Even the most scientifically minded senator will know next to nothing about how quickly heavy-duty trucks emit nitrogen oxide and other pollutants, health risks those emissions pose to humans, and how those emissions can be curtailed through cost-effective measures. EPA scientists, by contrast, can devote her entire career to nitrogen oxide. Down the hall, a different EPA scientist can work to identify new pollutants. His neighbor can stay abreast of the latest pollution mitigation technology in the trucking industry. And across the way, a medical expert can study the health effects of various pollutants, including on sensitive groups like people with asthma. Working together and with input from the public, these experts devise and continually update regulatory standards that keep our air clean and our bodies healthy. That's the Clean Air Act at work, just as Congress intended. Now, that's what's at stake in this battle over Chevron, because what the Supreme Court has done in the past 2 years is sharply curtail the extent to which the judgment of these agency experts, it's been so critical over the decades to protecting our air and our water, to ensuring we have safe drugs, to protecting the integrity of our financial systems. What the court has done is in decisions last year and at the end of the last term, it sharply curtailed the extent to which judges have to respect the decisions of these experts. And what it's done, to put it in simplest terms, is it shifted responsibility from the agencies where Congress put it, the unelected generalist judges who are not experts. And so now what's going to happen in our post-Chevron world is that these major cases now are going to be decided not by judges who are respecting the expert judgment of the agencies, but by judges who may have their own personal views about the environment, about the agencies, who will over time sharply limit the ability of the agencies to perform their mission. This is a dramatic moment in our history. These agencies that are at threat go all the way back to the New Deal. And only time will tell, I think, how serious this is or will be, not just for the integrity of the law, for our environment, our health, safety of our drugs, the integrity of our financial institutions. There is a lot at stake here.
Now, at the time you wrote the book, the Chevron decision was not yet released by the court. You did mention it, however. So does this mean you're going to have to write a follow-up to the memoir in order to?
I have written and laughed. I might say something. Hopefully, there'll be a paperback, and maybe I'll say something at the beginning. But let me just say one more thing. I retired from the court for many reasons. And I'm comfortable with that decision. But I'm especially comfortable with it now because I thought as a judge that the Chevron framework did a really good job balancing the importance of agency expertise, yet preserving the power of the judges to rein in the experts, the agencies when they exceeded their jurisdiction. I'm not interested, personally, in spending, my judicial career trying to figure out how we're going to interpret statutes in this new world. And particularly, I'm not especially interested in doing it in a system that's going to weaken these. So the answer is no, I'm not going to write another book. Done.
All righty, this is my last question for you, and it's one for the students. You were a public interest lawyer, you were a government lawyer, a law firm lawyer, all before you becoming a judge. What did you learn in law school that turned out to be important in law practice? In 2 minutes or less.
Not read the XX expert. I went to, this is for the students. I loved my law school, University of Chicago. I had great professors. And, we read at their feet, we read the big Supreme Court decisions. They taught us to read these cases. And they taught us to tell the difference between sound judicial decisions and decisions that were, one might say, less sound. And what they mainly taught us, University of Chicago didn't have an ideology. These were just great professors. But what they taught us is that the role of the court, the role of the federal courts, is to protect individuals from overpowering government, excessive government power, and to protect individual rights, individual constitutional rights. That's what I learned in Chicago. That's what I saw these great Southern judges doing during the Civil Rights Movement. That's what I argued federal courts should do in my cases. And that's what I tried to do in my 30 years on the DC Circuit.
And it's been a wonderful career, and I've enjoyed my conversation with you. I'm sure there are questions from the audience at this point. I'm going to invite Roger Citron. He will probably take issue with your comments about administrative law being boring, since he does teach administrative law. But I know he has some more questions from the audience. Thank you for being here. I appreciate our time. Oh, you don't have that.
Hello, Judge. I never imagined that I argued a case in front of you. It would be I asking the questions. And I'm so delighted that you're here. So thankful to the Gould family for putting this event together. Um, I do hope any of the students who are watching on Zoom that you will register for my administrative law class in the spring. Got a lot to discuss. I have 3 questions from the audience, and I may have 1 or 2 of my own. But let me start with a question that is somewhat personal. And this is, it's a question from a vision scientist. And there are 2 actually on this page, this card. Can you imagine how things look? That is the first question. Do you dream in images? If no, when, if no, did you lose that ability? So there's 2 questions there.
So there's actually an answer to that. I didn't lose my sight until my mid-30s. So I have a whole collection of visual memories. I mean, I know what mountains look like. I know what the stars look like. I have a huge catalog of visual memories that I've never lost. So yes, I can imagine. And one of the things that is absolutely critical to that whole process is my wife and my children who help me see who describe for me what they're seeing. My whole family, all my kids, our grandchildren are this way. They naturally describe me what we're seeing, whether it's, a person or a mountain or what the sky looks like or what it looks like outside the window. What they're doing is they're fleshing out the images that I already have in my brain. I call my kids in the book audible artists. And they're all, even the littlest grandchildren, do it naturally. And it enriches my life enormously. When he and I are going for a walk, we live in the country, we're going for a walk and describe the Ridge Mountains to our left. And she'll tell me about the mist on the mountains and the trees. And I know what a mountain looks like, but now I know what those mountains looks like at that very moment. So yes, I have lots of visual. Dreaming? Sure. I dream in images. I don't know how accurate they are. I have no comparison, but yes. But again, I think the question my guess is my answer to that question is very different from someone who's been blind from birth.
Yes.
Right?
Thank you so much for answering that. This is a follow-up question about a subject that you just discussed with Dean Langan. So in your decision to recuse yourself in the currency case that you discussed, did you consider the possibility that your presence on the panel as a blind person might have been a crucial form of representative justice? That's one question. And then how was the case ultimately decided?
Well, I'll start with that one. I recused myself. Another judge took my place, and the court issued a pretty good decision saying, yes, there had to be some standards and some deadlines, and they remanded it to the district court to do that. So it was pretty close. It was probably the same decision I would have reached. 4 months ago, I was at a conference of blind lawyers, and one person came up to me and they said, Judge, I love your book, except I don't agree that you should have recused yourself. And I think that lawyer was reflecting what this question is, which is, wasn't it important to have someone on the court with that particular perspective? I did think about that. But I thought it was far more important. First of all, my views about the accessibility of currency were irrelevant to the case. So, I had to, even if I decided to sit, I had to put those issues aside, concerns. But the overwhelming concern I had was for the integrity of the court and the integrity of its decision. And no one questioned that decision because I wasn't on it.
Yes, thank you. I want to ask a question about the DC Circuit Court on which you served for a number of decades. Can you say a little bit about, as an institution, how the court, what steps it takes, both sort of formally and informally, to function as an institution? That is, to be consistent, to be coherent, to be collegial. Can you say a little bit about that?
Yes, it's, you say formal or informal. I would say it's,
Oh, both.
yeah, I would say it's mostly informal. So when I joined the DC Circuit in 1994, the majority of the courts were judges appointed by Republicans, had extremely different views about many policy issues than I did. Yet we worked together. We were able to issue unanimous decisions in many areas where you would not have anticipated it. And it was because even though we had different views about environment or voting or whatever, we all were committed to the principles of judging. By the way, that's chapter 6 in the book. And it's actually the art of judging, and it is an art. And we were all committed to that. And by following the rules of judging, I call them principles of judicial restraint. It's not just me, but what they are. We were able to the maximum extent humanly possible, to put our own policy views aside and reach unanimous decisions. Now, we were only human. We weren't perfect at it. And sure, there were decisions that were, I worry, less judicial than they should have been. But overall, I thought it was a remarkably effective judicial institution. And my concern now, and it's basically the point of the book, is that those norms, those informal norms, are breaking down in our judicial system. And that's very dangerous for our checks and balances, and in the end, for democracy.
Yes. This is a question from the audience. So it begins, thank you for your defense of civil rights. And what legal arguments could be made or could be made to protect the civil rights of undocumented immigrants that now may be facing, or who now may be facing, the possibility or the threat of mass deportation? If you feel comfortable answering that.
This is why it's so important that law schools like Touro are committed to training the best lawyers they can, and they're committed to social justice. Yesterday, the New York Times had an article about several groups of immigration lawyers who are organizing to do just which is to organize themselves to protect the statutory rights to the maximum extent they can. Now, they know they're doing this at two headwinds that they got a big problem with. Number one, courts are hostile, and it's going to be harder and harder. And number two, it's an area in which the President of the United States has maximum discretion. So it's going to be a huge challenge for these lawyers. But to me, it's why it's that those for you students who are listening, that you become the best possible lawyers you can, and that when you graduate, you use your formidable skills to protect individual rights in the field of immigration or any other field. It's going to be an enormously challenging time for lawyers, far more challenging than any I faced in my career.
Thank you. Thank you. It's been wonderful to talk with you. Thank you so much.
Say one more thing. May I say one more thing?
Absolutely.
Is that okay? Yeah. I just want to pick up. I want to finish an answer I gave maybe half an hour ago when I talked about what a profound experience it was to write this memoir. There's a second part of that that has been equally profound for Edie and me, and that has been the aftermath of the book. It's been out now for 6 months. I get 3, 4, 5 emails a week. Sometimes I get a couple a day. People who say, I read your book and it tells my story. We are both so moved by that because, when I was a teenager and hiding my retinitis pigmentosa from my friends, I thought it was just me. I thought that I was the only one doing this. It turns out that's not true. I wouldn't have known that if I hadn't written this book. And Dean, you asked me if I'm going to ever write another book. I'm not. But if I ever write something, I would write about how much it's meant to me personally and to Edie and me together, get this reaction from the book and to realize not just that I was going through this, I wasn't alone, but that hopefully hopefully the book will provide that confidence to young people going through this now that I didn't have. I just want to make that.
I want to thank you, Judge,
Yeah.
for being in a wonderful conversation with you. And thank you for bringing Vixen. She's been a highlight of the event this evening. I want to thank all of you for being here and thank you. Thank you all for coming. We will have a reception. I would like to also mention that there are books on sale, signed copies. We put the judge to work before he was able to get on stage. We had him sign a few copies. So if you would like to purchase a book, they are available here. And we will have the reception starting in just a minute. Thank you, everyone, for being here. And thank you again to Bruce Gould and this award. Good evening.
Thank you.